probably going to make today.
They also are going to have the option.
And I was like, not a flight included in my mind. It's like, he would do
test with us.
everything with me.
Or they can do the 21 questions or
I think that
the 3
so
questions per
much
section.
time.
And you have the option of doing either or. But I don't
know. We're just going to finish. We've got the Equifax case from section 6. So we're going to finish that, and then we'll get to begin section 7. But let me just explain a couple of adjustments on the schedule due to, as it turns out, my travel schedule and the like. The midterm usually is immediately before the break. I had put it on the schedule for the 3rd because I thought that that would work better. But I think it's probably best to do it the Thursday before the break and have finished all the way then through section 9. You guys have an option. The people in class have an option on the midterm at any rate. The people online can take the class. They send in answers to weekly questions, and their midterm, in fact, the answers to those questions, and they're evaluated on that as to what their grade would be for the midterm. With respect to the final exam, we're all together in a room, and you take a standard 3-hour exam, both people online and in class, and that's how the final examination grade is arrived at. For the in-class people, I generally give you an option. You can either take the exam on the Thursday before the break, because that's when it's going to be, or you can submit the answers to all the online questions that will be posted through section 9. Your call as to which you might prefer. And so if you look at, I would suggest if you're going to make that analysis to look at the questions that are posted, generally the stuff we've talked about in class. If you've done your reading and you've thought a little bit about the material, you also can see what the questions are in advance and see what you would like to do. And I think that's the best way to do it. Yes?
Is the in-class examination open book?
No. No, the in-class examination is the standard in-class examination. It'll be about 1 hour and 20 minutes. It's going to be, whatever the date is, I'm scheduled to be in Houston. I think, oh, actually I have it here, I'm sorry. It's the 10th will be the date. And I have to be in Houston, so it makes sense to use that class time instead of losing it for Houston. Next week, I have to be in Boston with the AAJ trial team, and that's the week you're going to do the complaint where it says draft complaint for injunctive relief scheduled for the end of this week. You'll actually be able to do that next Thursday, and we'll post that information. I'll bring you that information on Tuesday, and you don't have to come to class to do it. All you have to do is draft a complaint for injunctive relief based on a fact pattern that you will receive. And that will be the class that's scheduled for the Thursday, the 3rd, when I have to be in Boston for the AAJ trial competition. So you've got 2 different projects coming up depending on how you'd like to deal with it, one of which everyone will do for the next week, not this week, but next week, which will be the drafting of complaint for injunctive relief. That's scheduled for the class on the 3rd. As long as I have it before the class that begins on the 8th, that will be considered timely. And then your midterm examination, for those of you that choose to take it, in class will be on the 10th. So it's your call. I would suggest you look at the questions first and see what you prefer. The online people have to submit all of those questions. And that's the other thing, by the way. All of the questions through section 9 for online, or for those of you that choose to do it by your midterm, are due by midnight on the 21st, the day you return from spring break. So
You need to take an in-class midterm
on the 10th, or
submit all the online questions by the 21st.
that is correct. On the online questions posted through section 9 on the 21st. Okay? Any questions? Looks like you do.
Me?
Yeah.
No.
Are
I'm
you
good.
good?
I got it. Yeah. I wrote
Pretty
it down.
straightforward. I mean, and those that haven't seen my exams in the past, you go downstairs in the reserve area and take a look at them. I do think the value of going through the questions is that then you have all that information assembled for when it comes time to final time as well. Because now half of the assembling of all that material into a comprehensive package is available to you for when it comes time for the final. So
How do we access the online?
you just go online, it's all there. And that's, by the way, if you ever miss a class and you want to listen to the audio, it's online, it's not password protected. Actually, I think if you go to, it says online classes, coin remedies, it's relatively easy to pull up. Okay? Yeah, sure.
So you said March 1st, we're receiving the information for the complaint?
Yeah, I'll give it to you next Tuesday.
Okay, and then March
And
3rd,
we'll
you
post
will
it
not
next
be here?
March 3rd, I have to be in Boston.
Okay, so we won't have class that night, so it's
You will not
not
have
due
class the
until
3rd.
the following Tuesday?
That is correct.
You want a hard copy or is this an email thing?
Well, I think you should figure out how a complaint would be filed, and I think, well, actually, there is a difference. Let's talk about that. There is a difference now, for the most part, as to how you're filing and where. If you're filing anything virtually in federal court, you're still going to send a hard copy in, but you have to be capable of filing documents electronically in federal court now, especially here, and I imagine in most other federal courts, but definitely in Boston. And if you do not, the documents aren't accepted. And there's a little online tutorial if you want to go down and look at it, and actually work through it so you know how to do it. But the Boston office, the filings have to be electronically done, and that way they can make sure everyone gets copies of everything. And what's also advantageous for those that are considering filing litigation, you can go online in Boston in the district court and you can find out everyone else who's suing Home Depot or some other company like that and actually pull up the complaints and things along those lines. You gotta be careful though, what you pull up at some point, they charge you to even view, much less print. So you wanna be careful. It's relatively modest expense, but you have to give them a credit card so that they can, your Pacer account, and charge your Pacer account for it as well. Many courts are moving to an electronic filing of material. So, and again, looking around at this group, you guys all have, well, most of you appear to have some pretty good skills in technology, which I think give you a real advantage, but actually more and more are becoming a necessity to practice. Certainly the federal courts are a lot more user-friendly from an electronic standpoint than our state courts. So that's your choice, and doesn't really, you don't have to tell me what your choice is today. I may ask you next week, just so if none of you are coming for the exam on the 10th, then I won't have anyone here to proctor because you're all going to do it. Let me just caution you one other thing, and it seems odd to me, but I've seen this on a couple of different occasions over the years. So some people take the exam, and I think some people take the exam and they say, oh geez, that'd be a lot of work to go get all those questions and do all the answers and review all the material. So they figure, well, I'll just come and take the exam, and what the hell, that has to be easier. And then I read the exam and it's real crap, okay? And I think most of you know me, and should expect that if you give me a bad exam, I'm going to give you a bad grade because that's what you've earned. So you shouldn't be planning on taking the exam because it's less work. The fact is, you still have to review and prepare and get ready and start to think about what I might ask you so that you can write a coaching blue book. And so it's not the easier way out. I don't know whether that's Coles to Newcastle, but it always surprises me that with the choice you have, that there's occasionally there are people who make the choice, and I'm thinking, what were they possibly thinking? Because it's not an acceptable exam, where the take-home aspect would have seemed to be a much wiser route, right? That seems to me. So.
Excuse me.
Yeah.
Did you say there's a take-home version? I'm sorry, I came in late.
I know, so you can listen to the audio later. Because I'm not. Okay, and I'll explain it to you later as well. But you have options. Okay. Let's talk about this week. We have a few different things to talk about. But before we finish up with Equifax, let's talk about Rule 56, because I usually like to start with the rule that we're supposed to be working on during the week. In civil cases, Rule 56 is an incredibly important motion. And in civil cases, I don't know, 7 times out of 10, there's usually a summary judgment motion of some sort that's filed. And so you have to be cognizant about what the rule does, what the procedure is, and what its requirements are. And it really, the procedure is remarkably similar whether we're in federal or the state court of Massachusetts here. But let's talk a little bit about first what the motion is. You know, because I've told you what the standard is, that the standard is there are no material facts in dispute that rise to a triable level. The moving party is entitled to judgment as a matter of law. Well, what does that mean in the real world? Well, usually what that means in the real world is either the plaintiff or the defendant feels that there are facts that are dispositive one way or the other with respect to their case. I'll give you an example. Last year I had one. I didn't plead the case originally, but it was pled, and it was pled pretty much close to the statute of limitations period. And it was a sizable case, a significant case. And so what they spent a lot of time in their summary judgment motion developing was the fact that the complaint was filed. The complaint was actually filed, a discrimination claim, on the 300th day following his last day of work. Now, the statute requires that the complaint be filed 300 days from the last discriminatory act. Okay? So, it was the 300th. And then the question became, and it took some factual development, whether there was in fact a discriminatory act on that 300th day, because if not, then the argument is his claim's untimely. And so, and the case had an incredible number of other hotly contested issues. But that's why I think this is a good illustration, because there will be times where a single fact may be dispositive one way or the other. Remember, we saw in Dickey's, the presence or absence of the police officer in the store gave rise to legal consequences. And so I think in the abstract, when you think of what the rule says, you say, well, it's either there can be absolutely no facts in dispute in order to win, and that's not the case. The fact is there may be facts that we can establish that no one can dispute that could dispose of the case, like, well, maybe he didn't have an act of discrimination or whatever on the 300th day, and therefore he's out. And so, in the real world, we spend some significant amount of time trying to use summary judgment because, especially defendants' lawyers, worry and are concerned about what a jury could do in a case, because plaintiffs' lawyers would tell you as well, juries are incredibly unpredictable. You should never tell the client what you think they're going to do, because you don't necessarily know. We tell them what we think. They better understand it's what we think, because if you think you can predict them with some level of accuracy, you cannot. And so, especially from a defendant's standpoint, avoiding that risk, that high exposure, becomes important. So defendants almost always will test the waters with the summary judgment motion. In this case, as I told you, and I mocked them for it, you know, they filed material, and I am really not kidding, with my hand on the table here, probably 2.5 feet of material, depositions and affidavits and briefs and the like, 2.5 feet of material to say that there's an absence of material facts in dispute. Well, it seems logical to me that if there's an absence, then it should be like this thick, because you don't need 2.5 feet to say no one's disputing their stuff. And so, but even with that volume of material, they still move for summary judgment, because the fact is they were trying to show the absence of some specific facts that could be dispositive. And that's the way you have to think about it. Because from a standpoint of judges, this was likely going to be, I think I said it would be a 9-day trial, because they didn't want to be over 2 weeks, because then I'd get pushed back further. But it could have been, I would think, 7 to 11 is probably what this was likely, depending on how the expert testimony would have come in. And from a judge's standpoint, that ties up somewhere between 2 and 3 weeks of my docket. And believe it or not, and again, well, you should believe it because it's true, someone actually then will say, you know, Judge Forbes, you didn't dispose of many cases this month. So there are bean counters that track how efficient our justice system is, which is probably a good thing, because otherwise some judges will sit on cases and may not do much work. So someone is actually keeping track of all of that. But from a judge's perspective, that poses a problem. If I really want to administer justice, and this is a 3-week trial, and they've been waiting a sufficient length of time, they should get tried, even if it means the rest of my docket is really backed up for that month. And so, to some extent, the motion for summary judgment, some judges are more inclined to grant it, where other judges would be more inclined to make sure that the right of a jury trial is honored. But from a standpoint of the defendant, and even a plaintiff, well, maybe there are appropriate occasions to file my motion for summary judgment. If I'm billing, obviously I can charge all the money to bill to prepare that motion. And usually what happens is the motion is moved for with supporting affidavits, and also in both federal court in Massachusetts now, what's called an uncontested statement of facts. And that is an incredible amount of work, because the moving party has to, and the parties are supposed to confer as well, file with the court, with their motion, what's called an uncontested statement of facts. So they list, and I don't know, this, honest to God, hundreds of excerpts alleging uncontested statement of facts. And so then what we had to do, and what you have to do, again in federal state court, is you've got to go through all the record, all the depositions and everything else, and show by reference to specific pieces of evidence, statements, testimony, and the like, why that fact is contested, where the evidence in the record is that makes it contested, and then references for your own evidence that would establish other facts in dispute, material facts that would negate summary judgment. So I estimate in that case, and it was a sizable case, but I estimate in that case that for the plaintiff to create their motion for summary judgment with all the supporting material and put forward, I would bet it's a $25,000 to $50,000 motion in that case. The response itself might have been commensurate with that, but we weren't working on an hour. And so it can consume a lot of time and expense. The point is, though, still a lot of that. It's, A, you got to do this if you're going to get ready for trial anyways, where all the prior inconsistent statements are, where's your evidence, so you got to do it anyway. B, what it requires you to do is marshal all the evidence and have a better handle on your case, probably at the end than the beginning. Because when we do all this discovery, in that case there's probably about 30 different depositions that were done over a period of a year. All that information then has to be put in a useful format, digested so that it can be usable. Well, that's what summary judgment is really doing. It's marshaling all this information to see, in essence, well, what do you got at this point? What is this case about? And so, as a general matter, in civil cases, summary judgment is used to sort of flesh out what the case is really all about. And so, what we see is it can be used anytime after the complaint is filed, all the way up to trial, and there are some that will use it right off the bat when they get served with the complaint and ask to dismiss or in the alternative for summary judgment. Now at that point you haven't had any discovery, and so your obligation at that point, if you can't show material facts in dispute, is to tell the court by way of a 56F affidavit that you need to get some discovery, and with discovery this is what we'll be able to show. But you should be aware that if you don't properly respond to it, if you don't respond to it sufficiently clearly, making your case, your case will be over by way of summary judgment. That can end the case completely, and oftentimes does. I'll bet at least half the civil cases probably go to judgment by way of summary judgment. And so it becomes important to understand how it works, and the procedural devices that are used within it are also important. This uncontested statement of facts, the responses to the uncontested statement of facts. Until you actually sit down and either look at it and do it, you probably have no idea how much work that actually is. Because when you've done all these depositions, say, you know, where was it that the witness said that, you know, he had a panic attack on that day and could not return to work at that point? Who said that and where? And now, if we haven't kept track of the material sufficiently well, now we're rereading everything to try and find where that is. And that's what you do with summary judgment. You're going to do it for trial, but the ability to marshal the information you have in some usable format becomes important, not just for trial, but especially for summary judgment, because the court is going to then consider all the paperwork. And again, whether we're in federal or state court, not always will you get an oral hearing on a motion even as important as summary judgment anymore. The court doesn't have to grant oral hearings. When I first became a lawyer, and that would have been in '83, it was routinely, if you had a motions practice, there was a set motion day. You went in and you argued your motion. So we had a lot of work on our feet that we were able to do. The modern trend over the last 30 years is that there's a lot of papers submitted, and the court really decides whether they think oral argument would advance the decision in the case or not. And so a lot of times, you better be able to write that brief well, and you better be able to do it so that it says what you needed to say in a reasonable fashion. And don't expect that you're going to get the last word by way of oral argument, because you won't always. The last thing to think about with respect to summary judgment, like most of your motions and memos that now that the court, the modern trend as well, is there are page limitations. And you are expected to honor those page limitations. And if you cannot, you need permission to exceed the page limitations. Again, in our case, again, to me it's odd that if you really are saying there are no material facts in dispute, you shouldn't need more pages in your brief to say that. You should need less. But they ask permission to exceed the page limitation by 50%. 50% is 20 to 30. But again, I think that's somewhat self-defeating, and that's what you have to start to think about, is you don't just use the federal rule of civil procedure or the state rule, there may be local rules that govern the process of how that motion is carried out as well. Questions on summary judgment?
So both sides can move for summary judgment?
Yes.
And can move with the same case?
Same case or by the same motion? Both sides can move for summary judgment, plaintiff or defendant. Oftentimes that in Massachusetts, summary judgment, the rule is summary judgment can be had against the moving party. In federal court, each side has to move for summary judgment. What I mean in the first case is that Brittany could move for summary judgment against me. I could respond, and the court could, not without me even moving, the court could say, Brittany's right. There are no material facts in dispute that rise to a tribal level, but she's wrong as to what the law is. Coin wins, not her. Because understand, right, if we are saying there are no material facts in dispute, in essence, we don't need a jury judge. It just simply becomes a question of law. You decide who wins under the law. Well, the fact is, you're now empowering the judge to resolve that dispute, in essence, as a matter of law. She might be wrong on the law. She might move for summary judgment, and the court might well decide I should win. A lot of times what we have is cross motions for summary judgment. Both parties move for summary judgment. I actually considered it in this other case. But I wanted a jury. The facts were so egregious in my mind, and we had a significant punitive damage award request. I really felt very strongly that I didn't want to I wanted the jury to hear all the details leading up to liability, because I think it was likely that they would issue a significant punitive damage award under the circumstances of that case. Go ahead.
Okay, so summary judgment's filed. What you're saying is that the filing of that summary judgment triggers the court's ability sua sponte to knock out any claim they feel the summary judgment should be granted on.
Well, but that's an overstatement, okay? So let me just back up a little bit. If she moves for summary judgment, suppose she's only moving for summary judgment as to some of my claims. So first of all, the only ones the court could grant summary judgment on would be the ones that she moves on, or my claim in response to those claims, okay? And so those they can't. Because sometimes when we have a multiple count complaint, we don't move for summary judgment as to the entirety of the case, but only some of those counts. And so if we've got the standard one count complaint, say, and that's not standard, okay? We've got the simple one count complaint. Negligence. I hit her and ran her over with my car. She sues me on one count solely of negligence. She moves for summary judgment. Yes, the court could decide she's right, there's no material facts in dispute, but on its own, fine for me, even without me moving in Massachusetts. In federal court, each side has to file their own motion for summary judgment. Okay? You look like it doesn't make sense to you, but see, to me, it makes eminent sense if she is now said, and this is the analysis sometimes I think you've got to be careful to do too, is you say, well, if she moves to summary judgment, I will. Well, I've always worried about that, in essence, that then I'm in some significant way conceding that we don't need a jury. And so to me, that then empowers the court more so to be able to take on the role of judge, jury, and ultimate fact finder. And that's not what summary judgment is supposed to be about. Summary judgment is supposed to be about when we don't have facts that need a jury's resolution. And so if she moves for summary judgment, she, in essence, has conceded that, well, she doesn't see that a jury is necessary on these factual determinations. Well, then you're saying it's a question of law. That is specifically a judge's role, is to decide questions of law. And so if the court, in looking at that question of law, believes that I am correct under the law that I win, then they should be allowed to grant it for me, and that's just the way it works. Go ahead.
So if the court, motion for summary judgment is filed, and there's a response by the other side, and the court grants a hearing,
Yep.
that means that he's not automatically just going with the side that filed the motion for summary judgment, that there is some question in the judge's mind, is that correct?
I don't think necessarily that you could say that that's a clear read either. Judge could simply be giving the parties an opportunity to be heard, already had made up his or her mind. Sometimes the judge has read the papers, has an understanding, wants clarification on points, maybe asking to see if you would concede certain issues to make the case even easier to resolve on summary judgment. Sometimes, what some judges do is, she and I go into court and the judge screams and yells at me, and then she feels a lot better thinking she won, and then the court rules for me because they wanted to make sure everyone thought this was very fair. That there's a whole game and a dynamic, and all the judges are different, so you don't always know what's up there. And so I'd like to think that when they schedule a hearing, it means they're going to listen.
As opposed to taking you to the woodshed.
Yeah, well, then all of that, right? I've had a hearing. I had a hearing in the Court of Appeals, federal court. Didn't ask a single question, not a single question. I mean, I knew that, okay, so we'll give them a hearing and send them on their way, right? Because if you really, I'd much rather have a hot court. I mean, let's engage here, and maybe we can discuss it and resolve whatever issues. But to have a hearing with no questions, I mean, did you guys see the appeals court when they were here in the fall? Oh, most of the speakers hardly got through anything before the court was looking for, and I think serious clarifications on issues that they had as they might have debated the case among themselves. Because that's the other part of a multiple judge panel. They may be looking for you to help them with arguments against their colleagues and the like, or helping dissuade the one that may be undecided. And so I'd always much rather have a hot court, and and that gives you a better read too. But I mean, I've had both, and I really, I've been given a hearing, and with no one listening.
But the fact that they schedule one, they don't have to schedule one even if it's requested, they could just act on the vote.
In most cases, they do not have to grant that request any longer. I think it's a good idea to, even if they're gonna go against you, simply because then clients especially feel like they've been heard. And I gotta tell you, that people will say, I wanna hear what the judge has to say. I really don't think you do. Okay, I think this is a really good opportunity for you to take the deal that's on the table. And I can understand that. I think a lot of people feel that the wisdom that people within those roles have a certain level of wisdom that you and I don't necessarily possess, and that they'll be heard fairly. It's just not always the way it is. I don't want to sound like my friend John over here, but that sometimes they ought to, that after a while you get a pretty good feel for how things might go and what's a reasonable deal and what isn't. And no one gets everything they're looking for as a general matter. That's just a given. And that you ought to understand. Let me get
if you're drafting a complaint, right?
Yep.
Obviously, typically you're gonna have multiple counts.
Yes.
And what you do is you come up with a strategy of breach of contract, unjust enrichment, and all.
93A.
Yeah, 93A, and just, put everybody under the bus. But I guess my question is, let's say I have a really good case and I'm a plaintiff. Right?
Yeah.
And I draft it in such a way that I have like really crisp facts, right? But what I've noticed is that as you go through this process, right, you got like 95% of the facts. And even though you have the super strong case and you think you have every fact, it's just that little sliver of information which caused you to be like, whoa, I'm gonna put in negligence, I'm gonna put in misrepresentation, because if I don't get him on this, maybe I'll get him on that kind of thing.
Yeah.
So I guess my question is, let's say I'm the plaintiff and I have a really strong case and I wanna move for summary judgment.
Yep.
That would probably be the reason why I would only pick some of the counts and not the ones that might create
Absolutely.
some heartburn.
Absolutely, and remember, the point from the plaintiff's perspective about moving for summary judgment, more often than not, all you've got to do is win on any one of those counts if you want.
And
Right?
once they pay the claim on one, I don't care about the others.
You don't, suppose he files a 6-count complaint, all for the same injury. He's only going to collect once, no matter what anyway. And so, obviously, he would like to win on the one that provides him the most compensation and attorney's fees and interest and everything else, assuming one of those counts does that. But beyond that, if he wins on any one of the 6 counts, he's won. And so, yeah, you don't move, especially if you've got, counts 4, 5, and 6 are really sketchy. Then you pick your strong one, and if you've got one that you can win on, you move for summary judgment on that. And or more than one. But the ones that really are clearly, there are no material facts in dispute. And again, by the way, that's standard, and that standard is quite clear as to what it says. For some judges, that's a much more flexible standard than the rule indicates. And you can get the history, we're going to talk about that next week. You need to see what the judge's track record is on summary judgment. And you need to know that early, because that's an assessment as to whether we should start talking settlement sooner rather than later. If I know I've got a pretty good chance to get to a jury trial, I can hold out a little more and my number will be a little better as a plaintiff. If I think that this judge is a little more free with deciding the facts on his or her own and maybe not always in line with my view of the world, that means I've got to be a little more realistic about how quickly this case could resolve adversely to my client's interests. All of that becomes a factor. And that's pretty easily, and the same thing about, again, we'll talk about it next week, but what's this judge like on discovery? Some judges are pretty flexible, other judges, they tend to narrow it. So I need to know those things too, and you can investigate all of that these days. Go ahead.
How early on is the judge assigned to a particular case? When would you know when the judge is?
Again, that depends on where you are. When you file in federal court, you're gonna get a docket number on that case. That docket number bears the judge's initials. You know from the time you have a docket number what judge has the case. And oftentimes probate court here especially as well, because the numbers are randomly assigned to a judge, they should be able to tell you relatively quickly. Massachusetts Superior Court, the judges rotate among the counties anyway, so you never know who you've got. You'll know who you've got for a period of time, but that period can move around on you. That becomes a factor as well, especially in that case I talked to you about where they move for summary judgment. I wanted the judgment wanted, who the motion was filed while the judge was there. I wanted that judge to keep those papers because I thought that, as it turned out correctly, that was a pretty good judge for my side of the case, as that judge would see it. And some of that is just fortuitous, it's at least in Superior Court, because it could be assigned. I could have a really good judge this month, my case gets, instead of going to trial in February, it ends up being in April. Now I got someone completely different who I really don't want. That's luck of the draw sometimes.
So are they on, how long is their rotation? Is it?
It depends,
6 months
it
or
can
a
be,
year?
it can be 60 days, 30 days, it can be by quarter. And sometimes when we say by quarter though, it could be quarter, but they're not rotating next quarter, they're still there. So, I think Judge Agnes, he's been in Worcester now for over a year, but that doesn't mean next month he's not gonna be in Middlesex.
I have just one question. I want to just clarify. You mentioned that moving to summary judgment, your documents you file, you need a supporting affidavit. The federal rules though say that you could file for summary judgment with or without a supporting affidavit.
Yes.
Now,
You don't
without, I'm thinking maybe you have a 12B6 motion, it comes in, you bring extraneous evidence, it moves to summary judgment,
Yep.
you don't need an affidavit.
Yep.
Is that it?
Yes, you don't need an affidavit. Most times, parties move with supporting affidavits for summary judgment to show the absence of material facts in dispute. But there are some cases occasionally that are so clear from the complaint and the answer that you don't necessarily. That would tend to be, if it's just apparent from the pleadings, that should probably be what's called a judgment on the pleadings, motion for judgment on the pleadings. But usually summary judgment is supported by affidavit, but the rule specifically says with or without supporting affidavits. Usually there are supporting, and not just an affidavit, usually there are supporting affidavits with summary judgment. Okay?
In practice, when you file a complaint and the other party doesn't respond within 20 days with an answer, which happens very
Yes.
customary. Every time I've seen that happen, the judge always gives them more time. So how often would you say that you'd be successful in issuing, as the plaintiff, motion to summary judgment because the other side didn't answer, have everything
Well, but I wouldn't.
defaulted as admitted?
I wouldn't file a motion for summary judgment in the circumstances. You file a request under Rule 55A to default them for failure to answer. When you have a complaint, once you've been served, you have 20 days exclusive of the date of service to answer. Now, as he said, think about it. So the person gets a summons to complain. Not everyone acts on it right away, especially if they've been sued before. It's no big deal. If they haven't been, they'll act on it right away. But they call your office, and then they have to get an appointment. They have to come in and see you. They have to come in then either at that point or later with money before you're going to do anything on it. And so 3 weeks can actually move pretty quickly. But so by the time you make arrangements and do some investigation, you may be outside that 20 days, okay? And so either you need an extension of time, or you're gonna have to file a quick motion to dismiss, or you're just not gonna do anything figuring, oh, what's he gonna do right away? Now, what he can do right away is on the 22nd day, he can file a request under Rule 55A to default you because you haven't responded within the time period. Now, if the court issues the default, and it's pretty much a ministerial function. Look at the papers, the return of service, the request, you should be defaulted. Then you get a notice of default. Your client gets a notice of default. He calls you and says, what the hell's going on? You say, well, I don't know what you say, because you should definitely be better than this, okay? But at any rate, now you bring a motion on the 30th day, 35th day, 40th day, okay? You bring a motion to remove default and file your answer late, okay? 99 out of 100 times, the court's going to allow you to do that because they would like your client should have an opportunity to be heard, even if you're a schmuck, because you didn't dot your I's and cross your T's. The fact is, frankly, the fact is a lot of times, you may not even have heard that client until after 20 days have elapsed. So it's not necessarily your fault. What I see as your fault, though, is when he shows you the summons and it shows a date of service, you now need to act quickly. It's not one of these that you can wait. So you got to do something. You should be doing something to protect their interests. But as a seasoned attorney, you also know for the most part that if you go in 30 days from the date, you know, the service was technically made, remove default and file the answer, or just simply to file your answer late because they haven't even issued the default yet. I can't imagine there's too many judges anywhere that are going to really default you, unless you're going to clown in the past, and unless this is part of your practice, and then you've got a different story. But the fact is, you should, in all likelihood, get to file that answer late. But the default itself should be, upon your request under 55A, be entered. The service, you're supposed to file your answer within 20 days. And do not use, or a response of pleading, do not use this discussion to say, well, Professor Coyne says it's really not that important to do things timely, because it is important to do things timely. And that's why sometimes you got to act more quickly. And when we talk about this really thorough slam-bang investigation under Rule 11, which you still should do, sometimes that has to be done on the weekend, perhaps, if you're running out of time or whatever. And don't shortcut it, because I told someone today in a different capacity, you've got to bring me all the supporting documentation. You know, when can you get it? I'm not sure. Well, you know, I can't do anything until I've seen all the supporting documentation, and you've got to make sure you do the same. So you wouldn't use summary judgment. You use request for default under 55A instead of 56. Anything else? Yep.
One final question, just so I'm clear on this. That the court
And you
will...
all should be doing, I wish you were, I know you should be doing summary judgment motions in motions. Go ahead.
Okay. So the court will not grant summary judgment for any count in your complaint unless you file a motion on either side.
Yes.
That is correct.
Yes.
They won't take it upon themselves to look at the facts, see there's no genuine dispute, a material fact, and grant. I thought you said they did that in state court. Sue was part of that.
No, they did that in
Yes,
Massachusetts.
but-
The moving party files, and there's no facts, but the law that they used to file the motion is incorrect, then they'll fine for the other party based on your reasoning.
Yes.
Summary judgment. I think it's
That's right. What I said.
Right?
Yes. If she moves for summary judgment, again, she's the defendant, I'm the plaintiff. She moves for summary judgment against counts 1 and 2, but not 3 of my complaint. The court could determine that she is right, that there are no material facts in dispute on counts 1 and 2, but grant summary judgment for me, not her. But count 3, she didn't move, I didn't move, count 3 still remains. The court on its own can't go in and dispose of that count.
Got it.
Okay, and that's the key. But yeah, they can actually, if she moves on counts 1 and 2, and I don't move at all, the court could still, in Massachusetts State Court, the court could still nonetheless say, I'm right, she loses on counts 1 and 2.
Does that mean those counts are gone? Is that, or it's just that
Well,
there's
she
summary
was,
judgment?
you were the defendant this time? Yes, that means, she was the defendant. No, that means I have won summary judgment on, as to liability. I assume liability, I don't know whether they've assessed damages. If there were some certain, it would be both. Did I just lose you now?
So those 2 counts are gone now?
No,
She's
no,
she's the plaintiff.
in our latest example, she's the defendant.
Oh, I thought she was the plaintiff, okay.
She was before, but I changed it. She's the defendant.
Okay, so you're suing her.
I'm suing her.
You move, she moves
The summary judgment saying he can't establish causation under counts 1 and 2. the court says she's right, no material facts in dispute. But she loses under the law. He's close enough on proximate causation that he wins. I find for coin on counts 1 and 2. Now.
So you don't have to try those 2 counts?
Correct.
Now, okay, all right.
Correct.
So that backfired, that
Yes.
strategy backfired.
Yeah, and that's the point. In state court, summary judgment can't backfire on you. I think in federal court it can as well, potentially, because, so in federal court, what that means is if you want summary judgment, you have to move for it. Well, in state court, we oftentimes do as well if we think we have a case. So you would have what's called cross motions for summary judgment. I think that that's a dangerous gambit sometimes, because in essence, you're conceding that we don't need a jury. And as a plaintiff's lawyer, that's not necessarily a good thing. And so I'm reluctant to file a cross motion for summary judgment when the defendant files it, because I could see how that could easily be turned around to say, well, my brother concedes that we don't need a jury here and there's no material facts in dispute. Because in opposing her summary judgment motion, all I need is one fact that's material, that's in dispute, in order to survive another day. One. And so when I move for summary judgment, I'm potentially, for some judges, that will make the issue too easily able to take away from the jury at that point. You still look puzzled.
I just want to make sure I understand this. So when the judge grants, when the judge denies her motions for summary judgment on those first 2 counts.
Well, not only did he deny her motions,
He
he said
granted
instead, Mr. Coyne, I'm going to grant you summary judgment on those counts. And she says,
Without
Judge,
a
he
motion?
never moved.
You-
That's right, he didn't file a motion. And Judge tells, he said, in sports, in Massachusetts, he doesn't have to. The law is, I can grant summary judgment for him on your motions, and that's what I'm doing.
In federal court, the judge won't do that. Her denial of her motions does not
It's
trigger.
a simple denial of her motion.
It's
If
not-
I wanted summary judgment in federal court, I should have moved for it.
Right, and those counts now go before the jury. Got it.
Correct. That-
But in federal court, do you have to still file a counter motion, because now you as the adverse party, do you have to prove that there is issue?
Listen, this is actually a good question. So let me clarify this whole process. When she moves for summary judgment in federal court, I don't counter motion her motion. I oppose her motion, okay? And I oppose you. The process of opposing a motion is usually by way of affidavit and a memorandum, okay? People oftentimes think, well, if she motions, I motion to deny her motion. And that's not the way it works. Is a response to someone's motion is usually a memo in opposition to her motion, coupled with affidavits, supporting affidavits if you need them or have them. Okay? Good?
Yeah, good.
Okay. Let's take a quick look at Equifax before we take a look at Timson versus Transamerica. He's a California branch manager for an employer with principal offices in Kansas. Purposefully established minimum contacts in Kansas and was subject to personal jurisdiction for the breach of the covenant not to compete. Even though he worked solely in California and went to Kansas only when he was an independent contractor in a training session, and when he was summoned for reprimand shortly before resignation. So his employer calls him out there to reprimand him, and we can use that later on as a contact against him and using Kansas to establish personal jurisdiction over him. That seems kind of ratty, doesn't it? Or is it, well, we don't need that. He's employed in California by a Kansas corporation. That's systematic and continuous. And I don't dispute that. But then you shouldn't need the Kansas reprimand, do you? Because if you need the Kansas reprimand, that doesn't sound like a voluntary contact to me. Mike, come out to Kansas, we want to reprimand you for you're being a bad employee. Okay, I come out to Kansas, and then you say, well, no, that counts as a contact, at the minimum contacts? Yes, that seems volitional.
He wasn't lured out to be served.
No, agreed. Not that situation.
So it seems plausible.
Doesn't seem a little underhanded, because I guess if I went to you as the lawyer and I had employees, say, in Michigan or Florida or Canada, you say, well, listen, you think you ought to have a staff meeting with those 3 folks in Boston, dress them all down, tell them the final warning, and then we can use that as a contact when we sue them in Boston to enforce their non-competes. That's all, nothing flawed with that logic, or, listen, this is what they pay us to do. We want to fight in Boston. No, I don't want to fight in Canada. Who the hell wants to go to Canada, right, Grit? No, but I don't want to go to I don't want to go to Kansas. Michigan, Florida I might want to go to right about now. But that counts as a contact. The case isn't here for that, but I wanted you to see that because there's something seems unfair about that. Equifax, this is the last in our bond sequence of cases. It says that the court abused its discretion in requiring Equifax to post only $10,000 in security under Rule 65C. Well, $10,000 is a lot bigger bond than we've seen in a lot of these cases, and that bond is supposed to be there to compensate the party against whom the injunction is granted if it later turns out to have been improvidently granted. He says 10 grand is insufficient. That's not gonna. Well, if you were his lawyer, how much do you think is appropriate? What's the argument you would make on the bond there? Because they want to enjoin him from working for how long? 2 years. So what should your bond amount be? 2 years worth of salary. And anything less is insufficient. Because if it's improvidently granted, it might take us 2 years to wind our way through the district court and the appellate court. Probably would, certainly through both stages, almost no doubt. 2 years worth of salary, he gets X times 2, maybe plus some interest, plus a little bit of attorney's fees if you can, but I don't know whether you have any statutory right to attorney's fees. Well, that's the argument you should make, isn't it? Did he make that argument? Didn't make any argument on attorney's fees.
That's the problem.
That is the problem, right?
No evidence presented to the extent of harm, and that's a clear indication that we've got to watch out for that.
That's correct. That's why, no, this is why you're reading it, because, you know, we tend to think of injunctions and just worry about the 5-part test, but the bond becomes a significant avenue to try and defeat the issuance of the bond. If I get a high enough bond, maybe they'll walk away from this. And so we now have to start to think about what our arguments are, and not just think about them, because here it did talk about evidence, presented no evidence of the extent to which he would be harmed. So what would your evidence be that you would present to the court? Go ahead.
Well, pretty obvious, like whatever his pay is.
Yeah, right. See if he's got an employment contract, or if he's got some type of a letter agreement, whatever he's got, you better be prepared to put it in either by way of affidavit, attach it to his affidavit, have him explain his terms of employment, or if it's going to be a live hearing, go put him on the stand and have him authenticate it and put it in. Right? Don't just take the case and say, okay, so now I got to do that. Well, okay, so what is the next step? How will we do it? Best way would be to have an affidavit ready. Have him have signed the affidavit. Have him employed at such and such. Go in through the affidavit about why he shouldn't be bound to the non-compete in his opinion, in his statement, but also what he needs for bond.
I think it's gonna require more than that. I think you're gonna have to have some sort of expert analysis that develops this theory that not only will he'll be basically underemployed, because he's not gonna be sitting home watching TV. He's gonna be working.
Expert analysis is expensive.
Right, but I mean, you.
And are they gonna be able to do it? Is that, like, who would you get? An economist to say, well, if he can't work in this industry, why can't he say that? If I can't, why do I need someone to pay someone $200, $300, $400 an hour? If I can't work in this industry, which I have worked for the last 30 years, I will have to look for employment in X, Y, or Z. I've done so, I've looked in the following areas close to my home, and jobs are generally paying X, Y, or Z. Right? Can't he factually put in much of the same information? When I teach evidence, I ask you guys to start to think about, because, again, we tend to think, we say, well, we'll just get an expert, because you can get an expert on anything, but you're going to pay them. And so, again, as we start to think about real-world limitations, whatever they pay the expert, they no longer can pay you. And they may not have money. This guy may not have money to pay anyone anyway, right? He might not have a job. And so resources are going to be tight as we fight this case. So we have to start to think a little more outside. Well, how could I put the same information in through him? And I think if you take a step back, you can do that.
I think if you ask the client to go out and start doing research, Mr. Client, listen, we're gonna save money here, become an expert in the ability to prove your
Well,
case.
he doesn't need to be an expert. What he needs to do is know what his own employment prospects are. Who should know at some point better than him what jobs he's looking at? And so, I think I'd be relatively comfortable with him doing it. I mean, I guess if I was really worried, and maybe he's making God knows what, so that there are some resources there, and there's a real chance early on to defeat the whole thing with a $2 million bond, then maybe I'd talk to one of these headhunters and see what they'd give me. And the fact is, maybe I could get that relatively cheaply too, because he's not working here. Maybe you'll get him next time you get your fee on the back end, right? I mean, we do have to be creative in this business sometimes as we try to look for resources to help us out as well. I think you could have done this, whether it's by way of having to pay an expert or obtain that information. The problem is, his lawyer didn't think about putting it in, and we can see from this case, as we've seen from the other, 10 grand is a lot more than a lot of these other folks are ever looking at. And we know, the law, and this is pretty clear, that the amount of that bond is highly discretionary. Especially, and by the way, both with evidence and here, this is the way appellate courts do this all the time. They are always going to dump it back on you. If you don't ask for something at the trial court level, if you don't make the proper objection, if you don't ask the court to issue this jury instruction, don't expect that they're going to save your butt on appeal, because what they're going to do, instead of save their own and their brothers, what they're going to say is, you didn't ask for it. You didn't put the information in. Can't expect us to figure out what should have been done in hindsight. You, as the lawyer, are oftentimes, that's what's going to happen here. And then your client looks at this and says, well, why didn't you? I don't know what your answer is.
Is an injunction always require a bond to be filed?
Yeah, well, the case law is, the answer is, the rule requires it. The case law is a little bit all over the lot in that regard. The rule is clear, although the last case the language was, it said, well, since the amount is discretionary, therefore, judge says it's discretionary whether they have to set any bond. Well, that's not what the rule says at all, but that's the way that's the way the judges have interpreted the extent of judicial power. Let's talk about Kinzer. And these are, if you're going to practice in Massachusetts, these next two statutes are very important. We've talked about 93A before, but now let's talk a little bit about 176D, which is consumer, 93A is the Consumer Practices and Regulation of Business Act, which governs both consumer v. business claims and business v. business claims. But 176D regulates insurance practices. And 176D becomes a really important statute to be able to use because insurance companies are not in the business of giving away money, even when you have a legitimate claim. Someone was telling me the other day, a lawyer was telling me the other day, this whole title insurance, which is relatively modest when you buy your house, you know, like $1,000 or something like that. There's been a fair amount of litigation over it because the claims don't show up for years until years later, and oftentimes they completely disavow the claim at any rate, and so you've got what may well be illusory insurance completely, and that seems to be the way some of those companies are doing business. Well, the argument may well be that could violate 176D as well, but so can more legitimate insurers, whether deliberate or otherwise, simply not honor their obligation to the insured. And so I guess that's what we ought to figure out under 176D, what their obligations are to the insured, because poor Michael Timpson would simply like to have his attorney's fees compensated because he was acting in the scope of, or in the course of his employment at the time of this unfortunate incident. So, well, why do you say that?
I actually think that the women should be in the locker room.
Really?
Yeah, I know you're gonna be like, oh no, she wouldn't have said that, but I think it's, I think that is part of like the professional athlete's business, and I don't think that when we had a male coach in college, he had to like knock, brief us before he was coming in. There's all these things, but if the woman goes in the locker room after to report, it's like this big deal, and I think that's not good.
Well, let me just ask you.
Sorry, this has nothing to do with kids.
No, it does, I think.
No, I don't think
Let me ask you this, though.
Yeah.
Steve Buckley, a sports writer for the Boston Herald, just came out.
Yeah.
So gay guys can't go in the locker room either?
No, I don't base it on sexual orientation. For me, it's more gender, and I feel like it's favored the other way, that if a male comes into a woman's locker room, it's automatically an issue, you know, on all levels. But if the woman goes into the male locker room, it's, you should have treated her more fairly, she wasn't doing anything wrong, they should have been clothed. It's a locker room. Like, so I
It's
think
where
there's-
you expect that they're going to do their business.
Right, and if
This
she
business?
wants, and yeah, like a locker room's a locker room. Like, I don't know. I think that they can do whatever they want in the locker room.
Well, can I ask you something? If they did something like this out in the street, we wouldn't be talking about civil
that's
liability.
different.
We'd be talking about lewd and lascivious behavior. Someone would be going to jail, no?
But that's why there's a locker room, in my mind.
Okay, no.
Because I think in girl locker rooms, like, I don't think that if guy reporters came in there after hockey, there would be.
Well, shouldn't they be entitled to though? I mean, if
the women are, yes, but I still think it's a bigger controversy.
Well, was Timpson in the? Amy
I
said this-
absolutely agree. I don't think, quite honestly, I don't think any reporter should be in the locker room. I think the players should be able to.
Oh.
I think the players should just be able to chill out, do whatever the hell they want to say, and then go out and put their game face on and say, okay, hi reporters, this is what I'm doing. I mean,
Well, why do you think they let reporters come into the locker room? And what's the purpose of that?
Yeah.
I think it's so they can get a player's fresh reaction right after.
Why do
they're
the
done.
teams let them in?
What's that?
Why do the teams let them in?
Because if they didn't, it'd be like they're hiding something, or there's something going on. Why don't they let us in? You know, there has to be all this like,
Well,
you know, they have to have guns or money in there, right? They're making side bags. I don't know.
They do if they're in Kinzer.
That Cornell is even worse. Hotbed of sporting activity.
No, access to the players is just a promotional.
It's a marketing.
Promotional theory.
It
right?
is,
That
right.
if you provide access to the players in a variety of different situations, it will provide for a more candid interview, and that will interest the viewers more than than staged press conferences or what have you.
Well, I
So
get
that's the
millions
theory
of
behind it.
dollars in free advertising in the Globe and online and ESPN.com by providing that access, don't I? So to the owners, it helps promote their game, their business. Well, isn't Michael Timpson really acting in the scope of his employment at the time he does this? As he sees it. As he sees it.
Well,
By the way, we had Jackie McMullen here last year, who was the Boston Globe sports writer. She says that, because I asked her about this case, it's not that uncommon in the early days especially, that if you went into the guy's locker room, you were not necessarily going to be treated, appropriate in all likelihood. I'll tell you another thing. Football players have screw loose anyway, don't they? I mean, seriously, right? Of all the sports, this is by far the most dangerous. And if you're expecting them to behave, right? I mean, I used to play football, and some of those guys, they really have a screw loose, right? You can't. It shouldn't be a surprise that someone truly misbehaves like this. And he did go in.
Yeah, but that's not a defense to legal actions. Like you said, if they had done this out on the street, someone's going to jail. So you can't take an action that's illegal and just say, because I'm in the locker room, I can do this now. Especially in my place of employment.
Once the team opens the locker room up to reporters, I think the players should be subject to the same type of behavior as if their mother was in the room. All right. So and that's only if they open the locker rooms up to the reporters, whether they be male or female. And they should, I don't know, I think they should just behave accordingly, or close the locker rooms off, like we mentioned a moment ago.
But the locker rooms aren't going to be closed off to the male reporters. And if I'm a female reporter and I want to get the story in the Access and I want a career in this business, I got to get inside. And if that means getting inside, putting up with some of this BS, I mean, I should have the right to make a living just like him and just like her, no?
Absolutely. The players, if they're not comfortable with it, they need to take it up with the appropriate people, which would be, their teams, the league, whatever. That's the way that I view it. I can understand why they might not want it, but if you're uncomfortable with it, you can't just take it out on the female reporter just because she's allowed to come in.
It says here, just to get some law into this, it says reviewing a grant for summary judgment, and this is in fact the correct legal standard. We determine whether viewing the evidence in the light most favorable to the non-moving party, right? And that's something to think about. So if I'm moving for summary judgment, the court has to weigh the facts, giving the other side the benefit of the doubt, right? You look at the facts in the light most favorable to the non-moving party. So she can say, it says black, but if someone else had said white, then the court really has to look at the fact that it could be white. You can't just take it in the moving parties say so if there are facts that could go either way. And then if all material facts have been established, the moving party is entitled to judgment as a matter of law. The insurance company, it says, has an obligation to defend the claim and to settle the claim once liability has become reasonably clear. His concern is that he wants his, I think it's $86,000 that he's out in attorney's fees here picked up, right? So in order for that to happen, he's got to show he was acting within the scope, of course, of his duties. And so how does one establish that he's in how would he establish that he's in the scope, of course, of his duties at the time he engages in this activity? What's the test?
Didn't he make what's the test? The Wang test.
The Wang test. And what's the right? What's the, it is. It happens to be. It still is the Wang test in Massachusetts. What's the Wang test? What are the three requirements of the Wang test?
It says is it the conduct of type that the employee is employed to do.
Okay, 1, 2.
Did the conduct occur substantially within authorized time and space limits?
Time and space limits.
So,
That goes in his favor?
kind of, I mean, well, he was in the locker room.
Time and space in the locker room.
I don't know about the time, but anyways.
Well, time is right after practice. He's still, he's not at a bar some night, with Ben Roethlisberger trying to argue that, well, we want to hold the Steelers liable for what he did. No, right. I mean, this is in the law. Time and space. And what's the third?
Was motivated by a purpose to serve the.
Motivated in part by a purpose to serve the master. So there's 3 requirements. As he saw it, because we're not arguing time and space, so we're arguing about 1 and 3. Is the type of conduct he's employed to do, and 3, it's motivated at least in part to serve his master. Well, what about that? I mean, let's go to 3 first, and then we'll come back to 1.
I would argue yes.
Because he's talking to the press, he's engaging with the press.
Because my theory would be that none of the players would want the reporters in there. So the owners or the management decide that the media can come in. So if they decide by me even being there, I'm fulfilling my obligation, my work obligation.
We also argued about team unity.
Well, right. He
That's
is
what you
promoting,
expect
I mean,
in a
all
locker
the.
room amongst football players, whether it's practice, before or after, you expect them to fool around, get hyped up, and bring it on the field.
And he's promoting team unity. If he's going to be telling Zeke and all the rest of the guys, hey, knock it off, well, then he becomes the outcast potentially. He's really trying to do the right thing here. And this is the thanks he gets for it as he sees it, no? Tell me about 1. It is the type of work he is employed to do.
No, he's not.
No, why not?
Why not? He's employed to play football, and he's not employed to go and engage in sexual harassing behavior to anybody.
So can I ask you about that? And I don't disagree with your statement. So does that mean that then the supervisor who sexually harasses his subordinate is never acting in the scope, of course, of his duties?
No, he's not.
No, he's not. So
No.
the employer isn't liable for the acts of the supervisor who sexually harasses his employee.
What do you mean?
Like in a work, you're saying, right?
Yeah, I'm saying in a work environment. If I sexually harass one of my subordinates, Mass Rule of Law is not responsible for that because I am not acting within the scope of my duties.
I think they would not be responsible.
I think the employer has a duty to supervise his managers so that they don't prey upon their employees and create this hostile.
Assuming they supervise, but every now and then
Because
stuff
it's a
slips
tort-
through the cracks.
It's a crime, and your employer is not supposed to
Tell that
defend
to
you
the Catholic
against a
Church.
crime. Well, that's a whole other issue, but your employer is not obligated to defend you if you create
We
a
actually
crime.
defended their motion for summary judgment on subject matter jurisdiction on that basis, saying the First Amendment doesn't protect crimes, because the argument was that it was protected activity.
I mean, it's like then you have to look at it and you say, is it? Now then you have to say, well, was it sexual harassment according to the statutes, or was it just behavior?
Okay, I'm going to leave you with a couple of questions because we're out of time, and I don't want to cut short on this. I do want you to think about that. So, is that what you're saying, though? Is that a supervisor who sexually harasses a subordinate, since that is not motivated in part by an ability to serve the master, that then that employee's claim can only be against the supervisor, not the big-pocketed employer, unless it's Francis's claim that you didn't supervise him properly. Because it means if it's an isolated instance that you supervise...
Or provide them with, sensitivity training.
So if I give you all the proper training, and I supervise my employees regularly, and one of them runs amok and harasses, the employer isn't responsible because it doesn't fall within WANG. I want you to think about that. I want you to also tell me how you're going to distinguish the Manning versus Grimsley case. Because if you read that case that's in the note as well, he's a professional baseball pitcher who intentionally threw a baseball toward hecklers. A pitcher, right? What, 90 miles an hour, throws a baseball towards a heckler, and was found to have acted within the scope of his employment because the heckler was interfering with his ability to perform, and thus quieting the heckler would result in better performance by himself and team. That's in the scope of employment, but Timpson isn't.
Maybe the
Timpson-
judge, no, maybe the
Timpson
judge
had an
like
intentional,
baseball, you know?
intentional had an intentional exclusion in his contract. I don't know about that baseball player. But I was thinking about that. What if there was a heckler in the stands and, you know, based on your evaluation of the mental instability of most football players, instead of firing the football, they leaped into the stands and threw their body at a
What do you think?
someone and then injured them.
Did you ever
That's an
see-
intentional act.
Did you ever see Terry O'Reilly? Did you ever see Terry O'Reilly? Jumps behind the Bruins bench, pulls off the guy's shoe, and he's beating the guy with his shoe, with his own shoe.
That's within the scope.
Well, it's hockey. That's right, your people might have the biggest free lose
Personal harassment though, wouldn't she have to be singled out? Because if they do the same thing here, my male reporters, then they don't care.
Yeah, but they don't.
don't.
Would this be sexual harassment? Is that what the question is?
Yeah, because I mean, if the male, if they're doing it, they're not picking her out specifically to do it.
Well, for discrimination, yeah. Right.
What?
Oh, no, you can answer the questions. I'm gonna, online questions, or take the midterm. On, up to section 9, when those are posted, up to section 9, or do the online questions. Right.
Just the last time.